that you have, great, thanks. The handout that you have is a full copy of the PowerPoint that we'll be covering today, and contact information at the end. So if there are follow-up questions, don't hesitate to send me. Okay. My name is David Nagle. I'm with national law firm Jackson Lewis. And if you think you're scared of the upcoming legislation, think about having a law firm of 850 employment lawyers. It's also an intimidating factor. We work in a lot of different areas of labor, employment, and employee benefits. And that's the end of the pitch. What I want to talk about today is the change to the regulations that goes into effect on December 1st. First, just a little bit of terminology. This has widely been publicized or used. It has been characterized as the overtime rule. It really isn't an overtime rule. Overtime is a consequence of what's happening. Let me also do one basic legal set of definitions, because I think I corrected Nancy. It's important to understand there are three different levels of law that are at issue here. The Fair Labor Standards Act of 1938 is legislation that was passed by Congress and signed by the President in effect in 1938. The Fair Labor Standards Act has, for example, that executive, administrative, and professional employees shall be exempt from the overtime obligation requirements of the Act. That's all the Act says. It then goes on, authorizes the Department of Labor to issue regulations to clarify the statute. And what we're dealing with now are regulations, the first of which went into effect in 1909 sometime, and have been amended a number of times over the years, establishing definitions for executive, administrative, and professional employees that are exempt under. Even by regulation, the special exception for computer employees came up. I'm sorry, is it loud? I apologize, I wasn't loud enough for the folks listening at home. So that's done by regulation. Regulations are promulgated by the Department of Labor. Department of Labor, headed by the Secretary or presidential appointees, so we do have changes with administration. A partner of mine up in our Washington office, for instance, was the wage and hour administrator under President. And quite frankly, the current Department of Labor leadership are the same thing that the Bush administration's Department of Labor leadership did, and that is they rushed to get in final regulatory changes before the president's term expires. And that's exactly what we're dealing with here. Oh, Steelers hit their stride, blow by Ritz just came up on here. News flash. Okay, so anyhow, we have the statute, the Fair Labor Standards Act, passed by Congress, signed by the President. The regulations that are promulgated by the Department of Labor, that's authorized under the statute. All statutes have enabling regulations that essentially put it into effect, and the court great deference to regulations promulgated by the department that's assigned responsibility for interpreting the statute. So that's what we're dealing with here. Nancy mentioned executive order. This is not an executive order. That's a whole different kettle of fish, if you will. That is something that the president issues directly by the White House, but it has much more limited scope. Executive orders, for instance, come into play under federal contracting programs, and the president has imposed a number of restrictions on contractors. The way that they work is not that they are imposed on the public, but rather they are announcements of a change or a new requirement going forward if you want to keep getting your government contract, this is something you will have to agree to. That's why we've had under federal government contracts, there have been certain affirmative action requirements. The Rehabilitation Act into effect for government contracts long before the ADA went in. So those are typically for limited application. We are not dealing with an executive order. We're dealing with regulations that went through the process that are scheduled to take effect. So going into details, changes that are imposed by the final rule. The final rule is what you call the final step, the actual regulation that will kick in on December 1st. When are they effective? December. And so how long do employers have to comply? Between now and December 1st. December 1st, they are effective. Some say, well, it sure would have been easier if we just wait till January. If you wait until January, you will have been out of compliance for a month and you can be sued for violation by either Department of Labor or individuals. So they have to be in effect on and after December 1st. The suggestion that I have for most employers is that if they're making changes, put them into effect in the payroll that includes October 15th, and that way you will be in full compliance by the time it goes in on November the 15th. So you'll be in full compliance by December 1st. But there is no grace period after that. The theory, of course, was that these were all announced back in May, and so you've had all the time in the Department of Labor's view between May and the present December 1st to come into compliance and be ready to go. What efforts are being made to buck the changes? As Nancy said, there are a couple of bills that have been introduced, and it is commendable that that various business groups are making such efforts. I think the likelihood of them having any effect is very, very remote. Because quite frankly, remember, it not only would have to pass in Congress, it's going to have to be able to override the president's veto. Nothing gets accomplished like that in Washington now. The one caveat I'll mention is we are in the political silly season. We'll have an election between now and then, so no one can predict with certainty what will happen. But based on what we know today, it is very unlikely that Congress could pass this with a veto-proof vote. Block this. So I think these are going into effect December 1st. It's very unlikely that they will stop. Now, what options do employers have to ensure compliance? Actually, there are a lot more options than you might be led to believe if you, the Department of Labor, which I normally commend as being one of the agencies that has the most informative websites. A great deal of information is available on the dol.gov website. It's easily searchable. You can get lots of information that, frankly, 15 years ago, it was extremely difficult, even for full-time employment lawyers, to come across a full index of administrators' opinions and the field handbook for investigators and documents like that. Today, everything is available on the DOL website, and I find it very, very useful. I rarely need to go any further to find the DOL's position. Now, to understand regulations, and this is going back to that intro section for a minute, the law is the law. You have to comply with it. The regulations are the Department of Labor's interpretation of the law. That gives you a safe harbor. They won't sue you for violating the law if you act in accordance with their regulations, because that's how they interpret it. But courts don't always agree with the Department of Labor's regulations. Normally, courts are supposed to give great deference to an agency's opinion. But for instance, in some circumstances, the agency may reverse position without any adequate explanation. There was, for instance, in the banking industry, loan originators had been the subject of a great deal of analysis during the Bush administration, and the Department of Labor had issued an advisory indicating that they were exempt. Well, almost immediately after the Obama administration came into place, the Department of Labor withdrew that interpretation and subsequently announced a contrary conclusion, but without any explanation for it, saying, no, they're not exempt. I'm not going to tell you why, it's just our position that they are not exempt. And so that particular example was one in which several courts said, you know what, the Department of Labor's position is not entitled to deference when we don't know how or why they reached their conclusions. So normally, the regulations are given great deference and in fact are viewed by the courts as the law, but they are not absolutely binding. Another example, an issue that's been in the headlines over the last couple with respect to unpaid internships. The Department of Labor has a very difficult standard to meet in order to justify an unpaid internship. The Department of Labor takes a very aggressive position that most interns are employees who should be paid. Haven't got the time, and this isn't the audience to go into it in great detail, but it's tough to meet the Department of Labor standard for an unpaid internship. Well, there was a lot of publicity over the last couple of years when a number of interns in the entertainment business, tea and fashion and other focused in New York City. Why? Because there are a lot of plaintiffs attorneys in New York City. And you can get high profile by suing Fox, for instance. But there have been a number of challenges to the Department of Labor's view that these people should not be unpaid. Sorry for the double negative. Well, the U.S. Court of Appeals in the Second Circuit, which sits in New York, has taken the position that they do not think that the Department of Labor guidance on this great deference. And they say the real test today for an internship is focusing on whether it's primarily for the benefit of the intern or for the employer. They have other factors they consider, but they don't apply as tough a standard as the Department of Labor does. So regulations are the DOL's position. They are not necessarily the law, but it's a safe harbor, if you will. Let's see. So there are, as I say, the Department of Labor is a source of information on their website. However, if you go to their website and look at material related to this change brought about by the regulations, they have a distressingly simplistic view of what the regulations do. They essentially say, all we're doing is raising the threshold and everyone will benefit because John, the supervisor in a warehouse, his employer is not going to give him a raise, so now he's going to get a lot of time off, and when he works, he'll get overtime and he'll be happy. And they have pictures of he and his kids going to ball games and him going and buying a new car. And then they say, and Susie over here, the HR administrator who makes $40,000 is going to get a $10,000 raise. And they have pictures of her going to the symphony and things like that. So the Department of Labor's view is that it's very simple. It's good for everyone that either employees will get more time off or they'll get big raises. Those are not the only options under the statute. They don't have pictures of John losing his job because now he's going to have fewer supervisors in the warehouse. But those are, of course, among the options that employers have to consider as they try to deal with the costs that are brought about as a consequence of this regulatory change. Okay, the Fair Labor Standards Act, it really is the FLSA of 1938. It's a Depression-era statute, and it was a response to the fact there were way too many employees seeking too few jobs, and therefore it was essentially a buyer's market, and employees, even though working, were making very, very minimal compensation. And so it was designed to reduce unemployment, and that's a consequence of the overtime theory. What they were trying to do is, in a tough market where everybody wanted a job, they could get individuals to work for 40, 50, 60, 70 hours a week at the same compensation. And so the objective of reducing unemployment was to make it so expensive to keep someone working over 40 hours that the employer would choose to go out and hire a second person, therefore less unemployment. Provide a fair day's pay for a fair day's work. It was to set a minimum, which had not there, and there had been certainly some abuses. It was a quarter an hour when the legislation went into effect. Changed a little bit since then. It says to reduce overwork and detrimental effect on health and well-being. That's the kind of stuff that Congress puts into legislation when they know it's not always going to be popular. But that's there. There is also, covered under the Fair Labor Standards Act, limitations on child labor. We're going to talk about those today, but again, just to recognize political realities, I try and point that out. The limitations on child labor were not so that little Timmy could go play softball a lot more. The limitations on child labor were a direct effort, a direct consequence of strong lobbying by unions who found that child labor was unfair competition for their members and was successfully pulling down compensation rates. So if you can get kids out of the labor market, it allows for wages to go up somewhat. So it was not just the interest in giving kids more time and Cub Scout time. Now, what about the Fair Labor Standards Act? I want to offer a couple of comments. One, it really is the most frequently violated employment law out there. It really is. Unintentionally, but it has a lot of requirements between the statute and the regulations, which many employers are unaware of and inadvertently will violate the statute, either on reporting of work, tracking time, break time, overtime compensation, issues like that. It applies to virtually everyone and has a number of requirements that do not always appear commonsensical to employers. And so I will tell you just from anecdotal experience, I've been practicing labor employment law for 35 years now. It is the most frequently violated statute. I always say that until I'm a sole practitioner, every law firm I ever worked for had inadvertent violations of the Fair Labor Standards Act. So it's not that employers are trying to cheat employees. There are a number of times when the statute's requirements may not be known to an employer and they may be violated inadvertently. Today, it is also the most frequently litigated statute. You know, years ago, all the cases were employment discrimination cases. I used one reporter, the Fair Employment Practice Reporter, and we got about 6 new volumes a year of this coming out in fair employment or discrimination cases. And at that time, we got a new volume about every 3 years on wage and hour cases. But today, there are more wage and hour cases filed every day in the federal courts across the country than there are any other statute, including any of the employment discrimination laws. So, frequently violated, it is frequently litigated, and it is the most expensive kind of claim to resolve. Not on an individual basis. If one person says, I get paid for my lunch period and therefore I'm due another 10 hours pay over the last or something, that's not expensive. The reason FLSA litigation is so expensive is because, unlike discrimination claims, which tend to be very personal in nature, they relate to an individual's experience as far as either being denied a promotion, denied training, suffering some kind of harassment or some other kind of discrimination. Very personal claims and class claims are rarely successfully brought anymore in discrimination issues. FLSA claims are almost always well suited for class, or what under the statute we call collective actions. Why? Because almost any action or omission on the part of an employer that violates the FLSA with respect to John violates the FLSA with respect to everyone else who's in a similar position. So if, for instance, an individual is required to continue performing some services for his or her employer after their shift ends, which would result in uncompensated hours worked, it's not that, in all likelihood, it's not that the employer is somehow targeting that individual. It's that the employer probably has a system improperly requires work after a shift. For instance, if we have an employee whose shift ends at 3 o'clock in the afternoon, but at 3 o'clock has to take her cash drawer out and count it out and get someone to verify it, and then maybe the trash, and then maybe straighten up inventory. But if she has gotten paid through 3 o'clock at the end of her shift, that's all time off the clock. Well, it's clearly work time. Under the FLSA, there's no doubt that the employee is entitled to be paid for that. And if one employee has had that unpaid work time, it's probably because the employer just treats that as stuff that employees have to do after their shift. So instead of being the individual who goes to the Department of Labor or who goes to an attorney seeking a claim, when the Department of Labor or a private attorney bring that claim, they will bring it on behalf of Susie and all similarly situated employees. And if that's a retail chain and it has 12 employees that get that every shift, 85 stores, and it's the same practice that's being applied everywhere, you can suddenly see how this just ratchets up to a very substantial amount of money. And by the way, if a private attorney brings the case instead of the Department of Labor, they can not only, well, regardless of who brings the case, if it goes to court, they're entitled to not only the unpaid wages, but an equal amount in liquidated damages. It's automatic that it gets doubled. And if it's brought by a private attorney instead of by the Department of Labor, they can recover attorney's fees as well. So is it big bucks? Absolutely. Uber just settled a misclassification case for $110 million. And it's misclassification because Uber had classified them as independent contractors. They established for purposes of the case that they were employees. If they're employees, they're entitled to minimum wage, and they're entitled to overtime compensation and liquidated damages and attorney's fees to settle for $100 million. And that was only the claims in California and Massachusetts. And they had 6 lawsuits filed within 3 days after the settlement for the other 48 states. So it becomes very, very expensive to have litigation over failure to pay overtime compensation, failure to pay for all hours worked, and for misclassification, typically in the exempt versus non-exempt. So it's a very expensive area to litigate. My law firm is defending 300 class actions right now on wage and hour issues. So very, very expensive. So it's a statute you need to be aware of, familiar with, and do all that you can to be in compliance with it. Last thing I want to mention about it being a Depression era statute is that it was for the public interest. Now, the reason that's so important is this is not a statute designed to protect each individual and make sure that he or she is getting minimum wage for all hours worked and overtime compensation after 40. As I mentioned earlier, one of the objectives was to reduce unemployment, to force an employer or encourage an employer to go out and hire a second employee rather than keep someone working a lot of hours. Why is that significant? It means that this is a law where an employee cannot waive the protections of the Act. It doesn't matter if an employee says, I don't need to get overtime pay, I am willing to keep working at straight time. Or if someone comes in and says, look, I really need to make some extra money, how about if you let me do the janitorial work? At night, you're paying somebody else, pay me and just do it straight time, or call it minimum wage, pay me to do that. Cannot waive the protection. An individual cannot waive the protection of the Act. They are entitled to minimum wage for all hours worked. They are entitled to overtime compensation for hours beyond 40 in a work week. And any agreement is, in legal jargon, it's void ab initio. It's void from the very moment that it's written. An employer and an employee cannot have an agreement that waives the protection of the Act. Why? Because it's not intended to protect that individual. It's intended to protect the public. So the public has an interest in the statute being enacted. Okay, what we're narrowing the focus now from the Act generally down to the white-collar exemptions, and that's the short-term language that we use for the executive, administrative, and professional exemptions from the overtime compensation requirements of the Act. In order for an individual to satisfy one of those, to be an exempt individual, they have to meet 3 tests. The first is the salary test. You need to be paid on a salary basis. A salary is a predetermined amount. It does not vary on that. It's paid on at least weekly. Sorry, some other news flash came up. Sorry, no, it's not my laptop, so I'm not familiar with it. It's a predetermined amount that is not subject to reduction because of variation in quantity or quality of work. In other words, it doesn't go up or down based on whether someone works 43 or 37 hours. Predetermined. Now, it does not have to be the total compensation that a person receives. They can receive payments beyond their salary, but the salary that meets the requirements of this has to be paid. Now, let me give examples of where people inadvertently run afoul of the salary basis regulation. Let's say a person has been given 6 days of sick leave during the year under your employee handbook, and they have utilized all 6 days. Stop. There are a couple of chairs up front if you would like, and I think there's one on the side over there. If they have exhausted all 6 days and they come in and say, hey, I need to leave at 3 o'clock today to go to the doctor, and you say, well, you're out of sick leave, so I'm going to have to dock you 2 hours pay. Seems reasonable, but you have just taken that person off salary basis compensation. Why? Because it's not subject to reduction because of variations in the quality or quantity of work. So if you essentially convert them to hourly in order to reduce 2 hours pay for that day, that's not consistent with salary basis compensation. Now, of course, it would be easy if I could tell you there were an exact formula for how long that loss of salary basis status goes and how long you can do it before you lose any exempt status, but it's really determined case by case. Different courts have looked at whether it was inadvertent and happened one time or whether it was in fact the pattern. If a handbook says you will be docked for any absences beyond it, then you've already lost. You've lost your salary basis argument and you would not be able to claim exempt status for people who are subject to that policy. So that's an example of salary basis. Now, is there any prohibition on giving an employee who's a salary exempt employee additional pay? No, there isn't. For instance, if you have a warehouse supervisor who gets a $1,000 a week salary, normally works Monday through Friday, whatever hours are required, and now we have a big project order that's coming in on Saturday, so we want him to work on Saturday. Can you pay them extra for it? Sure you can. You can give an extra $50 or $100. You can treat it as a above and beyond the call of duty bonus. You can award off if you want. You can do any of those things. They're permissible. The one thing I would advise against doing is being on an hourly basis to handle it, because that appears to be inconsistent with salary compensation, and it would weaken your argument that the person is salaried. But I think it makes sense to reward additional effort. But for an extra hour or two in the evening, that's part of salary compensation. Just because, like with going to the doctor, we're not going to reduce their pay for a couple of hours absence. So we don't need to provide financial compensation for a couple of hours extra. Okay, so the salary basis test is one. Now, the most widely spread conception under the Act is that people who are salaried are exempt, and that, of course, is not the law. Anyone who's come to class already knows that, but it's surprising to me how many small employers are still of the view that someone is salaried, that makes them exempt. That is absolutely not the case. Salary basis compensation is one component of the three-part test for exempt status. Any questions on salary basis? Yes, ma'am.
Is there something different with the public sector?
Do we have any public sector here? Okay, it's good to mention. I guess we have some. Public sector, the biggest difference that I point to frequently is that public sector cannot have comp time. And comp time in lieu of overtime compensation is never permitted in the private sector. That is something that is permissible in the public sector. That's the most significant because it has such a big budgetary. Okay, salary basis test. Salary level test. That's what we're focusing on today, because that's really the only issue addressed under the regulations that go into effect first. So after this slide, everything will be about the salary level test. The duties test is where there are specific requirements set out in the regulations for executive, administrative, and professional employees. Now, those terms all have common everyday meanings. That is not the meaning that applies on FLSA. You have to go to the FLSA regulations to read the definitions of executive, administrative, and professional employees. And I say that not to criticize it, but to make sure that you're looking at the correct standard for purposes of the FLSA. There are a lot of people who we might view under everyday terminology as an executive who may not qualify under the Act, and there are even more people who we are unlikely to as an executive in everyday conversation who do qualify under the Act. For instance, I've always said I can take a supervisor in a used tire installation shop and establish that he is an executive without difficulty. If they're getting paid on a salary basis and they're getting a level which meets the minimum requirement, unlikely after December 1st. But if they have those two things and they supervise 3 used tire installers, then they're an executive for purposes of the Act. That won't be difficult. It's an easy case. It's not just supervisory skills, but I give that as an illustration because we would rarely view that as an executive position, but for purposes of the FLSA, it meets the definition. There are a number of jobs that can or not meet the regulatory requirement because of specific duties. For instance, pharmacists are professionals, but in some instances, even an assistant pharmacist or one who's in training who may not qualify for the professional exemption may nevertheless be an executive if he or she is supervising a store, for instance, and are responsible for supervising cashiers. May not meet the professional, but may meet the executive requirement. So the regulatory definitions need to be followed. If you go to www.dol.gov, the Department of Labor website, one of the examples of, I think, very good, clear guidance that they are what they call the fact sheets on executive, administrative, and professional employees. It reduces the test down to 2 pages of really pretty clear language. So I can give you the sites on those at the end for anyone who wants them, or I can send them out. But I think really crucial that every employer who's considering an employee as exempt has read the Department of language on exempt classifications before just assuming that someone will or will not qualify as administrative or professional employees. Okay, the final rule is what we're talking about. The path to it is that in March of 2014, the President issued a memo saying that most of these standards had not changed in many years, and therefore this should be a study by the Department of Labor. In July of last year, the Department of Labor issued a proposed rule, and this is part of the Administrative Process Act, where an agency has to issue a proposed rule, which gives their first hint of what they are planning to include in the rule, and then they ask for public comments. They received 271,000 public comments in response to the proposed rule. And then on May 23rd of this year, they issued the final rule, and the process for that is they don't have any further discussion. They just get all of the comments, they evaluate them, they make some changes. In this case, there were a couple of areas where they did revise text of the proposed rule for the final rule, and then they have to publish it in the Federal Register, providing a sufficient notice period. So they published it on May 23rd, and it goes into effect on December 1st. There are 4 major changes brought about in the final rule. The first change is the salary level requirement for executive, administrative, and professional employees was $23,660 a year. It was actually defined on a per week basis, but that's what it was. It's up to $47,476 or $913 a week. So a very significant increase in the minimum salary level for an individual to qualify as an executive, administrative, or professional exempt employee. Second change is for highly compensated employees. HCE is the shorthand that the Department of Labor and folks in the field use. That was something that had been created by regulation just during the Bush administration, I think in 2004. Previously, we had only had executive, administrative, professional, and then computer employee exemptions, and each of them were a silo. You had to meet all of the requirements for any one of them in order to be exempt. When I mentioned the pharmacist in training, that person or one that has annoyed law firms a great deal, law students who are clerking for a law firm in the summer for many years were treated as professionals and paid on a salary basis, and firms didn't record their time and they didn't get overtime. And of course, law firms all thought that was swell. Well, they're not professionals. They're not attorneys. They haven't taken and passed the bar exam, and they haven't finished law school. So they cannot possibly qualify as professionals. Therefore, they were not exempt. Therefore, they were all due overtime compensation after 40 hours a week. So when I was a new lawyer, those summer clerks used to go to baseball games and dinner at partners' houses and go to the theater, and it was all a whining and dining thing. And then a few years ago, some law firms got sued for failing to pay overtime compensation to summer clerks who had not gotten job offers. And all of a sudden, there was this huge revelation that, they're not professionals. You have to record their time, and you have to pay overtime after 40. So suddenly, they don't get wined and dined quite as much as they used to. But anyhow, each exemption was a silo. You had to meet all the requirements of an exemption in order to be exempt. Starting back in 2004, the regulations also, sorry, I stepped away from my mic. Starting in 2004, the regulations also recognized a highly compensated employee of one who received $100,000 a year and had a duty of either executive, administrative, or professional employees. So perhaps they supervised employees but were not in charge of a department. Or perhaps they had, under the administrative exemption, authority to make decisions requiring substantial independent discretion, but they didn't have some of the other requirements. The highly compensated employee exemption was intended to be a catch-all for anyone who was making over $100,000. Change number 2 in the regulations is that $100,000 threshold has gone up to $134,000 to meet the highly compensated employee exemption. The rationale for those increases in salary level for both professional, executive, administrative, professional, and highly compensated is that they just had not been changed in a very long time, so that the $23,000 standard salary was below the government's poverty line for a family of 4. The theory and the more compelling, I think, argument is the second justification, that it was intended to make the question as to whether someone was exempt or not an easier question so that there would be less litigation. And I will say there is some merit to that, because the salary level had been so low that an argument could be made that almost everyone could meet that requirement. And so all the litigation was over satisfaction of the duties test. This is intended to say, we're going to push the salary level up a great deal, and that by itself is going to take a lot of people out of play as to whether they're exempt or not, and hopefully reduce the amount of litigation. There is an enormous amount of litigation. So there is a rational basis for that. Change number 3, and this is significant in a couple of ways, but change number 3 is that there will be an automatic increase every 3 years. The next increase will go into effect on January 1, which is a convenient time for adjustments to go in. They will announce 150 days before the effective change exactly what the number is, but based on anticipated changes in inflation and so forth. Their estimate is that the 47,000 and change will go up to 51,000 and change. The 134 will go up to 147 and change. The great significance, I think, to this change number 3 is it is the very first time that anything under the Fair Labor Standards Act has been set to have automatic increases. The minimum wage always is set in the act itself, and it always requires an act of Congress to adjust it. And so that's why every year you have an argument as to whether minimum wage should be increased, and if so, by how much. This is the first time the Department of Labor has promulgated a regulation that says automatically, based on economic factors, it's going to be adjusted every 3 years on this schedule, and we'll give 150 days notice before it goes into effect. For instance, I will point out that regardless of the results of the presidential election, this is a regulation properly promulgated by the Department of Labor. This will remain in effect unless a future Department of Labor changes or rescinds the regulation. Change number 4, and this is beneficial to some, but complicated. Change number 4 is, for the first time, employers are permitted to use some incentive compensation to satisfy the salary level requirements. Now, it's only 10% of the salary level requirement can be met through incentive compensation. The incentive compensation identified in the regulation is non-discretionary bonuses. In other words, a discretionary bonus is, you did a great job last month, I'm going to give an extra $2,000. That's discretionary because there was no prior commitment to it. A non-discretionary bonus is one where there is, for instance, a formula, or where an individual gets a commission on a set schedule, either time-wise or based on sales or based on performance, productivity, some other issue. If it's announced in advance and it is intended to motivate an employee to work harder or more effectively or more efficiently or to be more successful, that's incentive compensation. That kind of compensation can be used to satisfy to 10% of the salary requirement. Commissions, non-discretionary bonuses, or other incentive payments. It is not all non-discretionary payments that can be included. For instance, I had a client ask about night shift differential, saying, I have a person who's a janitor supervisor who gets $42,000 and he gets $6,000 of night shift differential. Has to get it under our policy. It's all written. We don't have any discretion. It's just what he gets for being in charge of night shift. And I will tell you, I went through it and did a lot of digging. And while night shift, for instance, is not meant as an example, if you go back and read all the data and the comments that the Department of Labor included with the regulations, it just is not the same kind of incentive compensation that they are including. They are focused on compensation that is intended to encourage and reward employees for greater productivity, profitability, harder work, more efficient work, things like that. Not something that comes along just because they work after 6 p.m. in the evening. A little more on that. The 10% rule is applied on a quarterly or less frequently basis. That's something that frankly was changed between the notice of proposed rulemaking a year ago we issued it. At that time, they said it should be measured on a monthly basis. They got a lot of comments from a lot of employer groups that persuaded them that was too frequently to try to make the assessment and the adjustment, and so they backed it off to quarterly. It has to be done on at least a quarterly basis, and you can have a catch-up. In other words, if you assume, based on someone's past performance, that they're going to make $10,000 in commission, and you get through the quarter, but because of poor sales in the last week of the quarter, they come up at only 8,000, and you had counted on them getting 10,000 on it. And in the next pay period, you can have a catch-up payment. It has to be done in the next payment, in the next pay period, and it only counts for the previous quarter. You can't also use that for the subsequent quarter. But you have one pay period in order to do, in which you can make a count if the incentive comp was too low. The 10% rule does not apply to the highly compensated employees, those who are in 100,000 compensation now. That's the one that goes up to 134. That actually allows incentive compensation to be included on an annual basis. And so what they're saying is you can't also apply to the salary portion on here. If you're using the highly compensated employee exemption for any people who are earning 100,000 will be at 134. You should study this carefully, and there are a lot of details on it. Most employers do not use that exempt classification, so I won't go into a lot of detail on it. But it tends to be, I will give you an example. It's the financial securities industry that uses it the most, where the people have low salaries that maybe $500 a week as a salary, but may get a year-end bonus of $75,000 to push them up into highly compensated employee. And brokers, for instance, typically won't be viewed as exempt. So this is a way that they qualify under the regulations. Okay. But for that highly compensated executive, they still had to have a salary of $455 a week. And what this particular regulation thing is, they can't satisfy 10% of that with incentive compensation. Incentive compensation, by the way, still has to be some kind of payments, incentive, commission, something like that, not an employee benefit, not lodging, not meals, not educational reimbursement, not health insurance or life insurance. It has to be compensation. The exempt duties test, this is the one that gets litigated all the time as to whether people are exempt or not, unaffected by the regulation going into effect December 1st. The December regulation makes no changes whatsoever to the duties tests. That's why I'm emphasizing those fact sheets off the Department of Labor website. Those are not being changed and have been in place since 2004. Was the last time those regs were changed. Okay, misconceptions about the rule. It does not affect other exemptions. No change to the outside sales exemption, which still has no salary requirement. And some of you, I know, in retail have outside sales representative employees exempt category. It is not altered by the regulations that go into effect. This also does not affect the professional exemption as it relates to teachers, doctors, and lawyers. And everyone is always happy. There is no minimum wage or overtime compensation requirement imposed for attorneys. We never get sympathy. So, non-exempt employees are not, another important misconception. Non-exempt employees are not required to be paid hourly, and they can be paid on a salary, but have to receive overtime compensation. I have had several who have contacted me and said, gee, I have this salaried exempt employee who's making $2,000 a year. Now I have to switch her to hourly. No, you don't. You can continue. You can continue to pay that employee on a salary basis, but if the employee goes into overtime, if the employee works in excess of 40 hours on a week, then you're going to have to pay overtime compensation for those additional hours. So there's no, is it easier to convert that employee like your other non-exempt employees to compensation? It may be, depending on your business. The Fair Labor Standards Act, and this surprises a lot of folks, it doesn't impose really any requirements on how you pay. You can pay salary, you can pay hourly, you can pay piece rate, you can pay job, you can pay a daily rate. You can come up with virtually any method for determining the compensation that you want, so long as you meet the minimum wage and overtime compensation. Whatever they work, when you divide their earnings by the hours worked, it has to at least be minimum wage. And if they worked over 40 hours, they have to be receiving at least 1.5 times the regular rate. The regular rate is all compensation, so it includes night shift differentials and any kind of piece rate bonus, anything like that. You have to add those all of those things together and then divide by the hours to get their regular rate. And a person has to receive 1.5 times that for the hours that are above 40. Gosh, I keep thinking you have a question for me, and you're just reminding me to hit the mic. So, any questions on that?
So
Yes, ma'am. Sure.
So generally, I guess in my experience, salaried people don't keep track of their hours. And so at this point, we should have really been all along, salaried people should keep track of their hours, so we know if they're going to 40 or not.
No.
Repeat the question.
I'm sorry. Oh, repeat the question. Good idea. No, it's okay. I'll do it since she wants it on the mic. The question is about recording hours worked for salaried personnel. Exempt, there is no requirement that we have an accurate record of hours worked for exempt employees. Why? Because they are receiving a salary that does not vary on the basis of quantity or quality of work. So it doesn't matter if they work 37 or 48 or 64 hours. So we don't have to have records on it. For non-exempt employees, there is a record-keeping requirement. We have to maintain an accurate record of hours worked, and that's how we know that if they go over 40. Now, you are absolutely bringing up a consequence that a lot of employers had not contemplated, and that is when you take that $35,000 a year salaried exempt person today and decide that we're not going to give him or her an increase, change duties, whatever, to put them up into the exempt category, we can continue to pay that person on a salary basis. And same salary, whether they work 28 or 32 or 35 or 39 and a half for 40 hours. But if they go over 40 hours, they have to receive overtime compensation. And that's when you need to be careful on what you determine the salary covers. If, for instance, the salary is intended to cover 35 hours a week, and you make it clear to a person when they're hired that they will be scheduled for 35 hours a week, you owe additional compensation between 35 and 40 because you've got the cushion there that you're going to be normally scheduled for 35. It may be less, it may be more. But if it goes over 40, then overtime compensation is required. Yes, ma'am.
But for non-exempt salary employees and they do not have the option to opt out, who has the burden of responsibility to track those hours?
The employer. The employer has an obligation to maintain an accurate record of hours worked. Now, you can.
I'm just not exactly sure how the employer can effectively track that.
You can tell them that they're not permitted to work at home. The idea under the statute, and frankly, I think it does make sense, is that the employer controls the workplace. If a person, we've had the question arise for years, people say, what do we do about unauthorized overtime? But you can discipline an employee for working unauthorized overtime, but not by failing to pay them. If they work overtime and you know that they work overtime, in fact, the law says if we suffer, and we've all suffered, some employees, but if an employer suffers an employee's work, the employer is obliged to pay for it. And so if, for instance, an employer knows that an employee came in on Sunday and worked for several hours, then even if the employee didn't get permission on it, the employer would have to pay. Now, there's nothing wrong with reprimanding the employee and counseling them that if they do it again, they're subject to discipline up to and including discharge. And there are employers. Now, it's beyond the scope of today's program, but I will tell you that one of the biggest developments in this area is, as you just raised, the question of work from home. And that's an area where the employer can take some steps to reduce it. For instance, if you're issuing phones to everybody and you're sending emails to them during the evening and you're expecting them to respond during the evening, you better be planning on paying them for that time if they're not exempt. Because you can't ask an employee to perform work, get the response of the work that they've done, and then contend that that's not work that gets paid for. It's that suffering anyone's work. Yes?
We have two questions from online,
Sure.
if you have time. This one's from James Hatcher. He asks if you could clarify the HCE change up to $147,000. If you have an advertising executive, as an example, who's making $125,000 a year, now are they automatically qualified for overtime if they work more than 40 hours?
Well, in a situation like, I'm sorry, so you put that in on the, they can hear, I don't need to repeat the question, right? Okay. That would be one of those situations in which the person did meet the HCE exempt status. They will not meet the HCE exempt status if they stay at the same level. So the employer should contemplate whether or not the employer will make an adjustment, is willing to anticipate that additional incentive compensation is available to meet it, and they have that catch-up opportunity at the end of the year for HCE instead of quarterly for the others. And if the employee will not qualify, then yes, I know it sounds odd, but a non-exempt employee, the employer is required to maintain an accurate record of hours worked. Now, let me throw one more practical guidance in the Department of Labor will never point out. That is a record-keeping requirement. If the employee doesn't work overtime, then the employee is still getting everything that they are entitled to. And the only violation is a record-keeping requirement, the failure to maintain an accurate record. There is a financial penalty for that. The Department of Labor, if they conduct an audit, they merely issue a letter saying you need to maintain it in the future. The risk of not maintaining an accurate record of our work is if the employee, for instance, is discharged 6 months later and brings a claim saying, well, you know, I really couldn't have gotten all that terrific work done in 40 hours a week like they expected. They knew I was really working 50 to 60 hours a week. So since I'm not exempt, I didn't make the $187,000 or 134, whichever it is for the HCE, then I'm entitled to overtime. The overtime rate on someone who made $125,000 a year is very, very high. So maintaining an accurate record of hours worked is required. And in the event of a claim of overtime compensation, it's what will either demonstrate or refute such a claim. The only ones where I have counseled clients that there is no real risk with failing to maintain the record is someone who's in a part-time position. It's very rare that a person who's scheduled to work 24 hours a week can work over 40 hours in a week without someone noticing it. And we do have situations where issue comes up, and in litigation, when it's on a class basis, for instance, we have a lot of to address it. We go back through IT and get records of the times that people logged in and logged out of the computer. We've had cases that are built on parking deck access time and when somebody drove into the building's parking deck and when they left. There are a lot of different ways that you can come up with efforts to disprove the amount of time someone claims. Yep.
One more question.
Sure.
So Tina has an employee who chooses to work 4 days one week, and the next week could work 6 days. Now, under the new rule, would they be able to still do that?
Under the current rules, they can't do that, unless they're a hospital or a nursing home, or the employee is a bulk petroleum driver. And the regulations really address both of those, all three positions. Generally, and I'm happy to follow up with that person if they want, but generally, each work week stands alone, even though you may pay on a every 2 week or semi-monthly basis. And so overtime compensation is calculated on the basis of a work week, and it is not permissible to have someone work 30 hours this week and 50 hours next week and just treat them both as 40-hour work weeks. You can have a person, for instance, if you have a work schedule where you have someone who has moved hours, they worked extra hours the first week, you could give them time and a half off in the second week to balance it out. But it's only on a trade in a 2-week pay period like that. But I'm happy to follow up with somebody on a specific one. The new regulations have no effect on that. So the December 1 regulation won't change anything about the payment on that. Yes, sir. And, the on-call rules are not impacted by this at all. The on-call rules are one of the, they have long been a difficult area under the law because in a phrase the Supreme Court in a case back in the 40s, the factual question is, has the employer hired to wait, or are they waiting to be hired when they're on call? It's engaged to wait or waiting to be engaged was the way the Supreme Court did it. And that's a very fact-specific question. I will say, ironically, as a practical matter, that's one of the areas where the advances in technology made challenges to that much less frequent, because since folks are available by phone or any beepers or any kind of device like that, the restrictions imposed on someone by being on call are much less onerous than they used to be. I remember years ago when you were on call, you had to stay home and wait to see if the phone rang, and that was more restrictive. And so we had a lot of legitimate factual disputes as to whether a person should be paid when they were on call because of the big restrictions that imposed. Today, there are not many employees who can really complain that the restriction is great. I mean, the fact that you may have to be able to respond in 2 hours, sure, it means that you can't go to Colorado for the weekend, but that's not an overly burdensome nation. If, on the other hand, you have to be able to report to the bank within 15 minutes or so, that would make a better argument for someone saying they essentially want me to stay, at my door to run to the bank on a moment's notice. So it's specific, but I think most employers can arrange on-call assignments in a way so that they really don't have to pay anything less than until someone gets the call and has to report. Good question, though. It's a difficult area. All right. Other misconceptions, and I guess we've addressed these. It does not change rules relating to payment of non-exempt employees, including the 2-week period question that came in. It does not require changes in pay to employees who do overtime. Remember, this is really going to just the 3 requirements for exempt employees. Impacts one of them, certainly makes it easier for many employees now to say I'm not exempt because of the new salary rates. At least that one objective of the Department of Labor of drawing a clearer distinction is true, and that should reduce some of the disputes. It does apply to Puerto Rico, it does apply to higher ed employers. It does not create changes, although are anticipated in the works for nonprofits. I did ask, and am I correct, there are profits here? Oh, there is one. Okay, well, I'll talk to both of you afterwards if there are some additional proposed regs and some guidance that have come out on nonprofits. That's an issue the Department of Labor has been remiss in, and I think they're sort of acknowledging that they need to provide more guidance. For instance, volunteers. Nonprofits can have volunteers. No one else here can have volunteers at work. If you have volunteers at work, you need to talk to a lawyer. I have had this discussion with folks recently. For-profit employers cannot have services provided by volunteers. Let's see. Yeah, and there is a lot of stuff in the works for nonprofits, so we anticipate some more coming out. I have an outline on it here, but because there are only two, I think, represented, you've got it in your handouts, and I'll be available to talk more with you on it. There are a number of issues that are being affected by it. You should also be aware, question on whether nonprofits are covered under the statute, but this part of this applies to everybody. For the Fair Labor Standards Act to apply to a business, it has to meet certain threshold requirements on revenue or have an impact on interstate commerce. There are very, very, very few for-profit businesses that do not have an impact on interstate commerce. If you take credit cards, then you have an impact on interstate commerce because many of them are based in wherever they are, Nebraska or Maryland or Delaware or someplace. So if you're processing a credit card payment through a bank that's out of state, that's an impact on interstate commerce. If you have to call suppliers out of state to send materials or supplies or equipment, if you ever send employees out of state, all of those things qualify as having an impact or an effect on interstate commerce, and they impose enterprise coverage. Even if you, by some chance, were not covered as an enterprise, individual employees can still be covered because of their position in interstate commerce. If they are packing boxes that are going to be shipped out of state, they are in the flow of interstate commerce and would provide coverage. I bring these up just to illustrate the idea that if anyone believes that their business and their employees are not covered by the Fair Labor Standards Act, it's really crucial to nail that down, because in 35 years of practice, I have only had a couple of instances where I was successfully able to assert the non-coverage of the FLSA. One was a kiosk selling vegetarian sandwiches that were all from local supplies. They're very small businesses to be outside. And so if you're counting on not being covered by the law, you're probably wrong. But if you're still going to count on that, really make sure you've looked into it and you've gotten an opinion. And an opinion from counsel is a good faith defense on this. It doesn't get you out of all liability, but it does eliminate the liquidated damages if you have a good faith basis for your position. And the two ways you can have a good faith basis is, one, if the Department of Labor investigated and found you were in compliance, and then you got sued by an individual you lost, you can point to the Department of Labor's conclusion as proof of good faith. And the other is if you get an opinion from counsel on it. So you can ask for that in the event of close calls. Volunteers, the rules on volunteers are unchanged. The only ones who can can volunteer to provide services without compensation or public service, religious, humanitarian objectives, shouldn't perform work that's otherwise performed by employees. For-profit businesses, this is not an option for you. Note the heading. We're talking only here about the nonprofits. Okay, non-enforcement period for certain providers of Medicaid-funded services. To get into a lot of detail. If you have Medicaid-funded services, go ahead and focus on this, and I can provide a copy of a section of the regulation, but it doesn't apply to most things. It goes into effect on December 1st. Now, this relates to what Nancy had brought up. There is a statute called the Small Business Regulatory Enforcement Fairness Act, which gives Congress a period of an opportunity to review a final rule and disapprove it. That has already gone and has been carried over because, as you know, they have various recesses at this time of year, but it's certain the president would veto it, so it would have to be, as I mentioned earlier, by a veto-proof majority, which seems very unlikely. Then there was also, this is the legislation specifically that Nancy was talking about that has been introduced, but again, it's very unlikely, I think, that there's any legislative approach to stop the effective date on these regulations. So what do you do as an employer in order to respond to these changes? Well, the first thing, it sounds simple, but identify those who no longer are going to meet the salary test. What I tell employers to start with is identify, generate a list of any exempt employees who made less than $50,000 last year, and just start with that. Some are going to be over the threshold and still make it, but you don't want to use the exact level because you may have had slight adjustments in compensation. So first you identify those who are no longer going to meet it, and then we're going to start looking at different ways that we can respond. One is, and this is what of course the Department of Labor wants everyone to do, just raise their pay. That's a simple, easy answer. Give everyone a raise so that they all meet it, assuming that they otherwise qualify as far as being paid on a salary basis and that their duties still satisfy it. But there are issues here. There are ways that some employers can choose to do that. You can reduce other components of compensation in order to justify the increase. You can reduce fringes. You can reduce pay for other people or provide smaller increases. I mean, there are ways that employers can say, okay, now the people in this category are exempt. I want to keep them exempt. I have to give a pay increase, and now I'm going to find out where I can save the money to justify that pay increase. But you also have to look at other consequences. If you have someone who is making $35,000 in a job classification, and you have another who's making $45,000, and you give the $35,000 store manager a $10,000 raise to get up into exempt, are you just going to leave the other person at the pay, or are you going to have to adjust across the board to maintain differences? I mean, that's an issue that, as a practical matter, you're going to need to consider. Some employers may use a red circle process where they will give someone a raise to meet the threshold, but then in payroll talk, you red circle them. They stay at that rate while other people continue increasing, so that you start heading back towards the disparity that you had. So that's a way that you can do it. But you do need to recognize the impact that it will have on others. Option 2 is to reclassify people as non-exempt. You are supposed to record their hours, and the employee has to receive overtime compensation when they work in excess of 40 hours in a week. A variation on this is you can reclassify them as non-exempt and adjust the rate, not by dividing the salary by 40, because then overtime hours are going to be very expensive, but adjust the hourly rate to account for the anticipated overtime. That's permissible. So reclassification can be cost neutral. If they've been getting 800 a week, you can divide it so it's $14.54 an hour at 50 hours. Don't set it by dividing for 40. In other words, figure out the overtime compensation for the last 10 hours there. It's going to be at 1.5 times the regular rate. You can do it, unless you're right at the bottom. You can do it so that it'll still be revenue neutral. It won't be a couple of things with it. It will be less popular than the assumption that people think they'll just get a raise to get up to the new level. We're going to say, no, you're going to be making the same as what you made before, but now instead it's not going to be on a salary basis, it'll be hourly, and for you to keep making the same, you're going to work for, and you're going to be scheduled for 40 hours at regular rate and 10 more hours at overtime rate. Now, of course, that is not an approach that you can use for the person who works 48 hours this week and 50 and 53 the next, because their compensation, if switching them that way, has to vary on the hours that they work. Unless you get to option 2.2, which is the fluctuating workweek method of compensation. Now, this is the one I'm always loath to get into this because it causes such confusion, but I have the example here, so I want to go ahead and point it out, and I will tell you where you can look it up on the Department of Labor website. This is called the fluctuating workweek method of compensation. It appears in the regulations at 29 CFR section 778.114. It's the fluctuating workweek method of compensation. Let me just explain how that works a little bit. It's setting a salary that will cover setting a salary that will cover straight time for all hours worked. Now you still owe overtime for the hours above 40, but you will only owe an additional half time. Why? Because the salary has covered the straight time. Think of hours as increments. For the first 40 hours, they have to get 1 unit per hour. And for the hours above 40, they have to get 1.5 units per hour. So if you set a salary and it covers straight time for all hours, then you only owe an additional half time for the hours that are above 40. The effect of this is that the overtime rate declines the more hours that they work. Let me give you an example here. And this one comes right out of the regulations. And the reason I decided I needed to use this is because I have made the mistake of trying to pick numbers out of the air. And I always say, I went to law school, so I didn't have to do math. So I try to use examples that are easy. Question first. Virginia law has nothing to do with any of this. It is all the Fair Labor Standards Act. The Virginia minimum wage is lower than the federal minimum wage. So Virginia law has no impact on calculation of wages. Virginia law in the wage area relates entirely to wage payment as far as when we pay people, when they get their final pay. Nothing to do on this. There are no restrictions imposed. Virginia law doesn't even address exempt classifications. No impact at all. But that's a great benefit. The only place I will say that there's a disparity between Virginia law and the Fair Labor Standards Act is on child labor. And that's why at the beginning I wasn't going to get into that today, but has no impact on the salary method of compensation. Yeah. Yes, there are state laws that prohibit it. Virginia does not have any impact on prohibiting it. There are some states, for instance, California They cannot stop bothering employers in California, and they have lots of limitations that are much more difficult. They, in fact, prohibit exempt as a, if you're a store manager in a store with 400 employees, they still take the position that only one can be exempt. Assistant managers in such a store do not qualify under state law for exempt class. Lawsuits get filed all the time there under the California wage payment law because there's no violation of the federal law. Virginia, as in, for instance, for the most part on discrimination laws, has just ceded this issue to the law and said that's sufficient and we're not going to expand on it. Here's an example, though. I want to give you 4 weeks of under the fluctuating work week method. Okay, let's say we have an individual who works up to 50 hours. Never worked in excess of 50 hours. This is makes the hypothetical. You have to have some limits on the hypothetical because you need to always make sure that the person will receive at least minimum wage for all hours. You have to, for your hypothetical, you have to set an upper limit. Upper limit in this was 50 hours in a week. The person's salary is $600 a week. Now, in 4 consecutive weeks, the person works 40 hours, 37 and a half hours, 50 hours, and 48 hours. All right. In the first week, the person is going to receive $600 because they worked 40 hours. In the second week, the person works 37 and a half hours, will still receive $600 because it's a salary. It does not go down. So they still go to the fluctuating work week method. So even though they work fewer than 40, they still get $600. In the third week, the person works 50 hours. So in that week, the person's regular rate is going to be $12 an hour, right? $600 divided by the 50 hours, $12 an hour. So the person is due half of that, $6 an hour, for the 10 overtime hours. So the person would receive $660 for the 50-hour week. And in the last week of 48 hours, the person's rate is going to be $12.50. So the person would get $650 because it would be 10 hours at half of the $12.50 rate. So that is a permissible method. There are 2 big disadvantages to it. One is your payroll people are going to quit because it's very, very complicated. And the second is because we're cheating them. Because the more hours they work, the lower their rate becomes. And so you need to, as I said to a client who insisted on going into this, I said, you need to budget for my time defending claims at the Department of Labor because employees are going to, you're cheating them, they are going to complain bad at the Department of Labor because the Department of Labor folks understand this. This is written out in the regulations. And so when they review that this is what is being done, they will be satisfied with it. It is absolutely permissible, but it is wildly unpopular with employees and with payroll folks. Yes, ma'am.
I manage a garden center, and so in January and February we go to, I only have one person. And so in January and February we go to 24.
That's a great, the question asked illustration of a garden center. And let me elaborate on that because you have one of the businesses where I think it does make sense to consider this. The fluctuating work week is beneficial to both the employer and the employee in circumstances, not typically when you have these 4 wildly fluctuating in a 1-month period, but rather when you have people who have made may have very seasonal jobs who, for instance, in the winter, I mean, I have represented golf courses that have chosen to use this method of compensation for groundskeepers because they say otherwise these folks, can't afford to stay with us through the winter because we only have maybe 20 hours a week. And so if you explain to those employees, we're going to keep you on this fixed salary all year long, and it'll be of great benefit to you when we have those short weeks through the winter. And the way we make it work for the golf course is it reduces the amount of overtime that we pay when you're working 60 and 70 hours a week in the spring and summertime. So there are certain employers who have big fluctuation where it's very beneficial to employees. And if you take the time and explain it to those employees, they in all likelihood will understand it. And in fact, what I have done with several clients that have utilized this is they have a training session on it where they really go over it and ask employees to give employees a copy of the Department of Labor regulation, and they have a training. So the employees absolutely know that what the employer is doing is legal, and they understand that they too benefit from it because they're getting essentially more pay in those otherwise short weeks that they would have. So there are times, and that's quite frankly is why the regulation was drafted, because there are positions where it makes a lot of sense for both sides on that. But if a retail employer tries to stick it in without adequate explanation to the employees, and if the intent is to just always get extra hours and there's never going to be any of the short weeks on it, it's going to be unpopular, and it can be challenged by the Department of Labor if there isn't really some benefit to the employee from getting paid on those short weeks. If there aren't any short weeks, put it that way, is the way the Department of Labor typically responds. They'll ask me, and I've had it come up when the first question that they ask when I explain that it's a fluctuating work week, they say how many weeks were short and how many weeks were over. And if I have to say 4 weeks were short and 106 weeks were over in that, then they start thinking it was in the language of the Department of Labor, a scheme to avoid compliance with the Act. And they will look to see if there's a way that they can find a failure to pay overtime. So, okay, but that site, all you have to do is go to Google and type in 29 CFR, quote it again, 778.114, and it'll take you right to the regulation. Yes, ma'am.
Option 2 is what we're looking at.
Sure.
To reclassify is there any expectation then now to go back?
No, I don't. It doesn't raise any kind of presumption because it's so crystal clear that the salary level increases on December 1st, and on November 30th, it was absolutely legitimate. Now, granted, you still have to meet the dues test and the salary basis compensation, but on November 30th, the lower pay was absolutely permissible.
From a legal standpoint, you recommend that employer have like an EWC and when it comes documentation what has the position called under, or is it just like be on the EWC mark?
Okay, the question is the recommendation as to documentation supporting the exempt classification. Let me address that in a couple different levels. First, I think it's a mistake for employer handbooks or any other material that's distributed to employees to go into explanation of exempt and the reason that a position is exempt. There isn't any duty at all to conduct training on that or to justify to employees your conclusion. I think it does make sense to inform employees as early as the offer letter, certainly orientation at some point, whether they are in an exempt or a non-exempt position, and explain the consequences, and use that. By the way, I always say this to associates that work for me: use all communications as an opportunity to sell. In other words, don't tell exempt people that you don't get overtime, well, that you're getting paid a salary that covers all of your time. Instead of telling them what they're not getting, explain the compensation, that they are getting salary because it presumes that they're going to work to get the job done. And that we're not recording their hours because we expect to work until the job gets done and get compensated for it. So I don't believe in trying to conduct training on that. I think your HR people need to understand it, but I don't think that the rank and file does. As far as having a document that justifies your internal, now I'm going to sound like a litigator that I have been for years. It's going to get turned over to either opposing counsel or the Department of Labor if we're in litigation. So you may not want to have that in personnel files or elsewhere. If you have it as part of a if you do, for instance, one of the recommendations I have here is to conduct an audit. If you do an audit or have counsel do an audit, it's a privileged communication, and that may be a way that you get a conclusion that is not necessarily going to have to be turned over to someone. Otherwise, it's recognized that oftentimes when you do an internal communication saying, you know what, I think Susie's position is not exempt and we probably should have been recording her hours and paying overtime. If Susie comes to that conclusion and files a complaint or a lawsuit, that's a document that you're going to be turning over. And so you want to exercise caution on creating documents that may be adverse to your interests later on. If that's done in a communication to and from counsel, or if it's an audit conducted by counsel, then the results of that are a privileged communication and don't get turned over. So, and while I'm a great believer in utilizing consultants, and consultants can help a great deal in this area and can oftentimes be much more cost effective than counsel, recognize that there is no knowledge associated with a consultant's work. So it's not the same as counsel. There's also not an ethics privilege on something like that. So just be aware of the consequences. Okay, so we've talked on option 2.2. Option 3 are just big picture options. You can reduce hours, avoid overtime, and reallocate work to other non-exempt employees, keeping everybody under 40. Or hire more part-time workers. Take a 60-hour job and make it into 2 30-hour jobs. And sometimes I've talked to some companies, it sounds like a lot to do to avoid overtime compensation, but if you're looking at restructuring and changing the span of control for managers, you may address it that way. Certainly, retail and hospitality, in my experience, retail and hospitality are the ones that are being the hardest hit by this regulation, because they're the ones, in my observation at least, that have the most exempt personnel who are at the lower end of the compensation scale. It's not. I worked with a client in the summer. It has close to 4,000 employees, and the first step we took was identify all the exempt personnel who make less than $50,000, and they had 2. Well, it's not hard when you only have 2 people to figure it out. In that case, each of them were within about $4,000. So if the level 1 was a part-time employee, so we decided to leave that person at current salary. She's part-time, so there isn't any overtime consequence. Just have to start recording her hours worked. The other was the night shift supervisor who was getting differential. And what we did in that case was we eliminated the night shift differential and created a new position, an evening supervisor of maintenance that has a $5,000 higher salary. So The net effect is negligible there. We just changed the policy so that he didn't get night shift differential, created a new job title that had night shift differential built into it. So for some folks, it's easy, but if you have a lot of people who are making $25,000 to $30,000 a year, working 60 hours a week as a manager of a fast food restaurant, or as a supervisor in a fast food restaurant, it's pretty tough for those folks. They are not going to be able to make all of those people exempt by giving them $1,000 raises. So it's the time to sit and look at other options. Are we going to convert them to non-exempt and just have them work 40 hours and no longer have overtime? Or are we going to increase the responsibilities, reduce the number of people in those? As for instance, I worked with one fast food restaurant that had been paying managers at all stores, and we ended up deciding that, you know, we can have a district manager who's in charge of 3 stores, clearly does qualify, and then we'll leave these other people on a salary basis and just cut their hours and not treat them as exempt anymore, reduce the authority that they have, and put authority at the next level up and can justify the compensation on that. So there are a lot of different approaches that employers can take to address this issue, far beyond the Department of Labor's suggestion that it's just reduce hours or increase compensation on it. So there are ways that you can try. The challenge is on responding to it, certainly reporting, and that's especially difficult. That's on my next page, but it's difficult for employees who have not traditionally reported time. They will perceive it, well, let me jump ahead. Employee morale, reporting hours, most people who have been exempt, who are now told that they're non-exempt and have to record their hours, will perceive that as a demotion, as a lack of respect. And so you need to, A, put the blame on the department and saying, I'm sorry, this is something that some lawyer told us that some bureaucrats in Washington required, and we don't have any choice on it. At least explain it that way, that it's not intended as a slight by me, but rather it's our continuing effort to comply. Going back where I was, loss of ability, loss of steady income, and that is true. Certainly a person who was a $30,000 a year manager of a fast food restaurant is, if he or she was working 50, 60 hours, and now we're going to switch them to non-exempt and try to make it revenue neutral, they are switching from salary to non-salary compensation. And while the hope is that it's revenue neutral for us and for them, their comp is going to start moving some, and they will have oftentimes been used to salary comp. Yes, sir?
Isn't it a little more complicated than that with benefits and other things that go back and maybe than just changing your fast food exempt status for a manager?
I mean, it certainly can be, depending on how the employer, and you're right, there's certainly a frustration that exempt employees oftentimes are in a different benefit package, have different tiers. They don't have to, but depending on the employer. The ones that I am talking about, quite frankly, in my experience, many of them offer very limited benefits in that area anyhow. So the ones who are treating someone as exempt at $25,000, $28,000 a year may not have as much of a benefit package. But you're absolutely right. If it changes them from getting health insurance added to no longer being in the pool that's eligible for health insurance, in some situations, it won't be significant. Now, on the other hand, one of the things that employers can do, that with the numbers that I just gave, it's not going to work very well. But if someone was at $40,000 and exempt, one thing an employer may choose to do is say, I'm going to give you the raise to the new requirement, but you're losing health insurance and you have it, but now it's going to be 100% pay on your part. And so that's a permissible way to do it. The Department of Labor, of course, they don't contemplate that. It's either cut the hours or increase the pay. That is a way to make it closer to revenue neutral. Yes?
I guess, if you do different things, raising someone up to that level, they still need to meet the duty.
Absolutely. There are three components of status. Salary being paid on a salary basis, not your deductions. Salary level, which is what's changed by this regulation from the 23 up to 7. And the duties test. The duties test is not affected by this, but it certainly is also not eliminated by this. And the only thing that most of us, the highly compensated employee is something that really only came about 10 years ago, and a lot of us don't naturally think about that one. That has a reduced duties test. That's the one that has high salary level, and it narrows or limits the application of the duties test. But that's, as I say, that's for people, we're talking people well over 100,000, and it still has to be office or non-manual work. That was a change that was put into the regulations because there are a number of people who engage in manual work who can make over that. I remember the illustration of the one that the U.S. Chamber used when trying to get the regulation fixed is those little boxes up on top of a crane like 60 feet above the ground. But suddenly they were being listed as exempt because they made $150,000 a year doing that. And so the regulations changed so that they were not exempt, despite having compensation that high because it was manual work. So, oh, yes, sure. Yep. Yep.
If you go that route, what happens with, someone stays over and have to do the job done, but during the day, they were doing something so they were on the
Great example. The question was if someone stays late and puts in an additional hour and a half, but you observe that they were not working during the day. You screwed up by not disciplining them during the day, and you owe them an hour and a half extra pay at the end of the day. The theory is the employer controls the workplace. You have the ability to discharge or anything less than discharge employees who are not working efficiently during the day. And so if you know that they work an extra hour and a half at the end of the day, or if you see them taking work home, or if you're getting emails from them in the evening with work that's been done, you are on notice that they are working extra hours.
Does that change if they left the building for an hour and a half in the middle of the day?
If they punched out that they're not working.
But in an office atmosphere, you don't have people punch like clock. They just come in, they work, and they might keep their hours. That's what I'm wondering.
Well, you're obliged to maintain an accurate record of hours worked. And I'm not trying to sound harsh, but the Department of Labor isn't interested in any defense that's based on, well, I just expect them to work, and if they had to get extra hours to do it, it's on their time. That doesn't. It's not even relevant to the defense.
The record keeping though, does that have to be a punch clock or can it be written?
The employer's duty is to maintain an accurate record of hours. There is no definition as to how you have to do it. That means you can use a time clock, you can use a handwritten timesheet, you can have people log in and out on their computer, you can have, as long as it has a method for an employee to show variation in their schedule, it's acceptable. My law firm, we just have an email that is sent on Fridays by secretaries to the national office, and it confirms that they either worked their 8:30 to 5:30 every day, or that they had a late arrival, early departure, or absence during the day. Mark it in. Yes, ma'am.
I think we discovered that, but my question is going to be the time off in the middle of the day is expected, understood by both parties. Your work schedule on certain days is 8 a.m. to 1 p.m. and you're given 2 hour break in the middle to do whatever you want, and then you come back and finish the day later because extraordinary circumstances, events or something.
And if you have something like that, then I make sure that the employee has initialed the sheet or done an email or whatever saying that today work time was 8 a.m. to 1 p.m. and 3:30 p.m. to 5:30 p.m. I mean, as long as you have a record, I think that the question that came, I think, and I'm not trying to state it, but it was that work is having to be done after regular hours because the employee wasn't efficient during the day. And the answer the Department of Labor has to that is you have the ability to control the workplace and to insist on efficiency during the day.
So if someone goes out for a doctor's appointment, 2 hours, the employer would have a way of having that person notified that that's what they're doing, and that would be offset by the hours, 2 hours that they have.
Sure.
At the end of the day.
Yeah, I mean, as long as it's during the same work week, you can do it that way. And the employer should, by all means, have some record of the hours that the employee was taking off. Now, you don't have to deduct their pay for it. You may allow a person, for instance, to take 2 hours of vacation or PTO or whatever you have and charge that for a doctor visit. That means that they use up their PTO on doctor's visits. That's certainly permissible. But if you don't record that, then you're in a tough spot to justify reducing or charging it to vacation. Okay, I only have a couple of slides left, and I know I'm at my time limit here. All the challenges are readily illustrated to you folks. You don't need to hear them from me. Does it provide employer opportunities? I will say, in the last of November, there will be a great deal of publicity on this. And it will be right after the presidential election, so we'll probably all be burned from both media and newspapers. I've said several times I'm going to give a tour in Ireland on 20th, I think, of November, and I'm planning to ask for asylum when I get there. But there will be a great deal of publicity to it, and so employees who are impacted by this regulation are going to be very much aware of it and have questions. And if you don't make changes, and people think that they're entitled to, as the Department of Labor says, more pay or fewer hours, then you're going to have issues. So I urge you to address it in advance. Oh, and as a friend of mine says, the Department of Organized Labor has also made an app available that allows you to record your hours and through the app to submit a complaint to the Department of Labor. So your ever helpful Department of Labor is there to make sure that they encourage compliance. I had a last couple, let's see, a couple of sample questions that have come up in other ones. You may have the same people that have the same job title, one exempt, one non-exempt. It is going to make it easier for someone who you have classified as exempt to claim that they are not exempt and should be overtime compensation. Be aware of the ripple effect of any changes that come about in consequence of this regulation. So you want to make sure that you look not just at the people who are affected by the regulations, but the impact of any changes that you make on others. What's the best way to communicate the decision to reclassify employees as non-exempt? I already mentioned. I think that if you explain to people that it's a change that you have studied long and hard, and you attended seminars, and you've read the material on the Department of Labor's website, and you have concluded this is what you have to do to comply with the law. They may not be happy with it, but they're less likely to blame the employer for the negative consequence they feel of it. So I would just urge that you do it as effectively, positively as you can. The last slide has my email address, so if there are follow-up questions on any of the materials that we've covered today, I promise I'm not going to bill anyone for a follow-up seminar. It's 11 o'clock, and I know retailers are always very attentive to getting out on time. Jeff Smith always to stand up at 2 minutes before the appointed hour and tell me he was going to ask the last question. And so I understand that you need to get back to your business. I will be here as long as there are any questions. And I thank you very much for joining us today. Thank you. Just so yeah.
I gotta figure you're gonna give
That's kind of in the middle of what the regulations.
Hey, Lon, how you doing, dude? Good to see you.
That's my question. So how many years ago last time
Well, you always have to pay them.
Nice not making good.
So I know this sounds odd, but if you're sending someone to Washington,
Yeah.
versus normal work hours, 8 a.m. to 5 p.m. If they can leave at 8 a.m., they get paid as early as they tell them they need to be there at 8 o'clock. So you have to travel inside the workday. And in many instances, it's outside the DOL website has travel.
So, yeah. What about travel?
Once the workday starts, until the workday ends, if it goes outside the hours, how they're doing this work, that's a different issue. They're coming to the store. If they have to report back to the office, but if they're working in Washington today, they have to be in their employment at 8 in the morning.
Oh, yeah, exactly. Oh, my God.
So a specific example would be the furniture show, where at the end of the day, you're going to interact with the vendor. So regardless loyalty on the drinking.
Or you can tell them that I'm going to dinner today. Do anything you want.
Where do you go? No, I just came back from
So this is, but.